We're going to kick off now. Hopefully some more people will come and fill up as we go. Welcome to Field Fisher, those who haven't been here before. My name's Nick Pimlott. I'm a partner in the regulatory group, and one of the things I do is public procurement. I've worked with a number of you here in the past. And Stephen May, my colleague in our dispute resolution team, he and I work closely together on procurement litigation matters. My background is advising on the sort of non-contentious side on both the public sector and the private sector side of public procurement. I've been doing it for about the last, well, since 2006 regulations, if you remember that. So we've come quite a long way since then. I've rather grandly called this talk "The Future of Public Procurement in the UK," but I think that's probably right because, as you know, the Procurement Bill is currently before Parliament, and that's what we are going to sort of talk to you about today. Hopefully this works. That doesn't work. Well, that's a good start, isn't it? You go and can you go and get someone? I will. I'll
tell some jokes.
I'll tell some jokes in the meantime. I'll do my introduction. You won't just see what's in the slides. So, just as a sort of bit of background introduction, sort of rolling right back to Brexit. Obviously, we had the public contracts regulations and the other procurement regulations, which are sort of a creature of EU law. They were preserved in the domestic legislation post-Brexit. And so we've been sort of operating on the basis, as everybody probably knows, of the existing sets of regulations up until now. And there was a time post-Brexit when we thought, well, maybe there's going to be no procurement at all. Maybe the government will abandon procurement as an idea, but they didn't do that. They did sign up to something called the Government Procurement Agreement under the WTO, which is an international agreement opening up procurement markets for signatory states, which include, broadly speaking, EU member states, the US, Canada, big jurisdictions, and one or two others. And they signed the Trade and Cooperation Agreement with the EU, which again incorporated procurement obligations on the UK. So the UK has international obligations to have essentially open, transparent, non-discriminatory procurement rules. Then we had the Green Paper. So the government put out a Green Paper, a consultation paper in December 2020 on grandly called Transforming Public Procurement. And it was, I was quite taken by some slightly grandiose language in the introduction by the minister. He said it was a historic opportunity for too long modern innovative approaches to public procurement have been bogged down in bureaucratic process-driven procedures. We need to abandon these complicated and stifling rules and unleash the potential of public procurement. I think we can maybe think at the end of this whether that ambition has been met by the bill. The Green Paper was followed by a White Paper, which is the government's statement of policy. That was a year later in December 2021. And actually, you know, it was actually, I thought, quite interesting because the government moved quite a long way. It put out some proposals in the Green Paper. It definitely listened in the consultation, and it moved on quite a few areas. So we had the bill that was introduced into Parliament in the House of Lords on the 11th of May this year. What's the significance of the House of Lords? Well, parliamentary bills can be introduced into either the Lords or the Commons. The most politically controversial ones tend to be introduced into the Commons. Ones that are not politically controversial tend to be introduced into the Lords. So that's a sign that this bill is not terribly politically controversial between the parties, but there are clearly kind of issues which have been debated in Parliament. It's quite a good time to be talking about it now. It's been through the so-called, it's been effectively finished in the House of Lords. So it's been through detailed examination in committee. It's been through detail, it's past the so-called report stage. So pretty much all the changes that are going to be made in the House of Lords have been made. And that happened like about a week ago, so I've had to do a bit of catching up on that. And when is it expected to become law? It's got to go through the Commons and expected to become law probably. I think when I've heard civil servants talking about this, they're pretty uncommittal, but thinking towards the end of last year. And there could be changes. So what we're talking about now is at least our best effort to understand what came out of the report stage in the House of Lords at the end of last week. And it could, of course, change in the Commons. Probably not massively, but with that health warning, it's not necessarily settled yet. So what are we going to do today? We're going to talk about two things, really, biggest things. I'm going to do an overview of the bill, covering quite a sort of wide range of different topics, not everything. If you think there's anything I've missed, please do shout. And please do chip in, by the way, along the way if you have any questions or comments or things you want to discuss. And then we'll have a coffee break, and then Steve will talk about the impact of the bill on procurement litigation. So this is a rather long list of things, and I will endeavour to get through it as quickly as possible in the next hour. And as I say, it's not. I haven't covered everything that I could possibly cover. So if you think there's anything that I've missed, please do say. Starting with the scope of the bill. So what the bill does is it repeals and consolidates all the current regulations. So we had the public contracts regulations, the utilities contracts, the defence and security regulations, and the concession contracts regulations. All of them go and become one big act of Parliament ultimately. That's quite helpful in a sense because you can look at one thing. On the other hand, if you're a utility, you knew you just had to look at the utilities regs and you could not look at the other ones. If you're in defence and security, you're in defence and security, etc. So, you know, it's good and bad. Now you have to read it all and see which bits don't apply to private utilities, for example. But you know, that's just a feature of the consolidation. I very boldly said there are no substantive changes to the key definitions of contracting authorities, utilities, and public contracts, and so on. I say bold, I say probably, because what the government has done in the bill is to essentially try, I think the policy is to keep in some of these lots of the same concepts that we already have in the procurement rules, but they've changed the wording. So they've tinkered with the wording and they've made it apparently simpler. And sometimes they've changed the European wording and sometimes they've kept the European wording. So I think the intention is no substantive changes, but I don't guarantee that there's not going to be some borderline. I think if you're a contracting authority now, you'll be a contracting authority. If you're a utility now, you'll be a utility. But I think there could be some borderline questions. One thing just to note, especially if you're a utility, is you're now a contracting authority because the term contracting authority is used as a catch-all to cover public authorities, utilities, and public undertakings. So you just have to look for the carve-outs for utilities. There are some specific exclusions for the devolved Scottish authorities because Scotland wants to retain the option of going back into the EU, so they don't want to change the procurement law too much. And there are some specific exclusions for security services like GCHQ, which we didn't have before. Financial thresholds, that's all in there, and they're the same as before, but obviously with the power to change them over time. Carrying on with scope, exemptions, again, generally consistent with the current rules. There are some different nuances. I've just highlighted a few points here which may or may not be of interest, but the so-called vertical and horizontal agreements, so contracts between contracting authorities and entities which they control or where they act in cooperation with other authorities, so-called horizontal arrangements. If you're familiar with procurement sort of law, you'll know about the so-called TECAL companies and TECAL cases and Hamburg waste case involving cooperations between authorities. Essentially, those have been kind of maintained, as far as I can see, without too much change. Very similar ability for authorities to enter into contracts with entities they control, as long as those entities don't exercise too much of their activities outside the scope of the relationship with their parent authority. Land and buildings, again, if you're involved in the construction or the sort of the property development area, this is a hot, difficult topic. When is a contract a public works contract, and when is it an exempt land agreement? Again, the bill contains exactly the same, more or less exactly the same exemption for land agreements that you see in the current rules, but we're going to lose all the EU case law, which underpinned the concept of a public works contract. So there are some likely, I think, to be some difficult questions about what is the boundary between an exempt land agreement and a public works contract. There's some simplification of the provisions for exemption, defence and security contracts, which is exceptionally complicated under the current rules, and a broad power to exempt on the grounds of national security, which wasn't. There always was a power to exempt on the grounds of national security, but the government, my experience, was always rather wary of exercising it. I think that's something which we might see being being exercised more in the future, especially as you're thinking sort of maybe sensitive technology contracts, things like that. So that's very quickly on exemptions. Principles and objectives. This is going to gets quite interesting. So first of all, they say covered procurement, which means above threshold procurement must be conducted only in accordance with the Act. I think that's quite helpful to sort of suggest. It does imply, it means that this is the complete code for procurement above the threshold. And the bill incorporates principles. So we have principles based on EU principles of non-discrimination, transparency, equal treatment, proportionality, all those things which it says in the current regulations authorities have to try and achieve. But this is what the bill says about the principles. Contracting authorities, and remembering that includes utilities, must have regard to the importance of delivering value for money, maximising public benefit, transparency and sharing information, and acting with integrity. Now, you can immediately see that that's a sort of, I think, a potential for some difficulty, because at the moment, authorities have duties to do things. They don't have a duty to have regard to things. And I think there is some thought that actually it's, this is potentially a downgrading, I think, particularly of transparency and sharing information, if they only have to have regard to the importance of it rather than actually achieving it. And it's also rather odd to say have regard to the importance of delivering value for money, because surely that's what you have regard to anyway. I mean, it's a pretty important, all these things are pretty important. Integrity. I mean, it's a bit odd to say, I had regard to the importance of acting with integrity, but then decided not to do it. So what does this mean? I think there's some odd wording, basically, and I think there is some opportunity here for disputes to arise over what these actually mean in practice. The one area which is a hard-edged sort of obligation is that contracting authorities must treat suppliers the same, sort of equal treatment, unless a difference between the suppliers justifies different treatment. A little gloss on that. That's a sort of non-discrimination rule. Because of the government's commitments under the government procurement agreement, there is a possibility for not treating suppliers the same. In other words, discriminating in favour of UK suppliers in areas that are not covered by the GPA. And that is, for those with long memories, the equivalent of Part B services. So health, social, legal services, things which are not kind of sort of regulated services. But mostly that non-discrimination, equal treatment rule will apply. An amendment which was recently introduced in the House of Lords, authorities must have regard to SMEs' barriers to participation and consider whether such barriers can be removed. This is again part of a policy to encourage SMEs, smaller businesses, to have access to procurement. There are the usual provisions we haven't really touched on. I'm thinking about lots, for example, pre-market engagement, things which would help SMEs. And contracting authorities, but not private utilities, but public utilities, must have regard to the National Procurement Policy Statement. which may be published from time to time by the government. And I think you may, again, be familiar with the fact that we already have a national public procurement policy statement, but that's again enshrined in the legislation. And the government has to think about all sorts of good things, promoting the public good, value for money, transparency, integrity, all that stuff has to be thought about and then reflected in a procurement policy statement. So that's the sort of overarching principles and objectives. I think quite a lot of similarity with what we've got, but as I said, some subtle legal differences which might sort of play out in sort of perhaps unexpected ways over time. So moving into some more of the detail, award procedures. At the moment, there are 6 award procedures in the procurement regulations, at least in the public contract regulations. There's the open procedure, the restricted, competitive dialogue, competitive negotiated, innovation partnership. I've probably forgotten one. I thought there were 6. And it's all down to 2. So effectively an open procedure, which is a single stage tendering procedure, and then something called a competitive flexible procedure. And the competitive flexible procedure, effectively the bill doesn't really say anything about what it involves. It basically says you can design a procedure which meets whatever needs of particular procurement, which is fine in a sense, but to my mind, certainly the public contracts regulations and even more so the utilities regulations don't really tell you a huge amount about how to run a procedure. They say certain things have to happen, but they give some guidance about what happens at the beginning and the end. But in this world, I think it's going to be really a question of authorities and utilities basically building on good procurement practice that already exists, and coming up with flexible procedures. And bearing in mind, you have to maintain equal treatment. There are transparency obligations. So all those things which ensure, in a sense, or ensure that criteria are properly developed and disclosed and bids are evaluated in a fair way. I mean, all that is baked into the bill. It just doesn't say so in terms of how the procedures are run. What was called a contract notice will be called a tender notice. The bill doesn't say much, if anything, about what that's supposed to contain. Must contain sufficient information to allow suppliers to prepare a tender, but the detailed content is to be specified in regulations, and that's a feature of the bill. Quite a lot of this detailed stuff, which is important, is to be decided in regulations to be specified by the government. Again, as you'd expect, there are provisions on conditions of participation, selection criteria, much slimmed down. There had to be a proportionate means of ensuring suppliers have the legal and financial capacity or the technical ability to perform the contract. But if you're familiar with the current rules, you know there are these long lists of kinds of information that you can ask bidders for, but that's all gone. The tendering periods, there are some time periods for waiting for responses to notices and for tenders. They are similar to the current. I haven't gone into the detail of those, and they are based on what's in the government procurement agreement. Kind of important change of language from the meat to the mat. The current rules require tenders to be awarded on the basis of the most economically advantageous tender. The bill, again reflecting the GPA, refers to the most advantageous tender. And the idea is that authorities can, the intention is to create greater scope for authorities to move away from very purely price-based, lowest cost tendering. Doesn't exclude that, but it's a sort of an encouragement to think that it's not just about the money, it's also about other things. However, the award criteria, in I think very similar terms to currently, must still relate to the subject matter of the contract, so you can't have completely off the wall award criteria. They've got to be measurable and specific and clear, mustn't break the rules on technical specifications, and be proportionate. So very similar, I think, to the current position, but with this sort of overlay of it doesn't have to be quite so economic. One thing that you won't sort of necessarily notice if you read the bill just as it is, because it's not in there at all, is there's no express requirement for the evaluation of the MAT to be solely from the point of view of the contracting authority. And the idea of that, again, is to allow authorities to take into account wider considerations than their own, as it were, particular interests. And part of this is to allow greater scope for the use of social and environmental criteria. Although the current rules already allow for quite a lot of social and environmental criteria. I mean, I was at a massive event a couple of weeks last week on sustainable procurement. There was a huge number of people talking about how to do sustainable procurement, public and private sector. There are already quite extensive rules under the current arrangements. There's, I mean, there was a procurement policy notice from 2020. Which requires, as many of you may know, social value to be taken into account in central government procurements with a 10% weighting. And this rather complicated social value model that the government's created. So it's all, it's all there already. So is it actually going to allow for greater scope of social and environmental criteria? Maybe, but we've already got quite a lot of that already. What is the MAT? Is the tender that the contracting authority considers, and I don't really understand this, satisfies its requirements and best satisfies the award criteria when assessed by reference to their methodology. I don't really understand how something can satisfy your requirements. Well, I suppose maybe it means it's sort of minimum requirements and then best satisfies the award criteria, but it doesn't phrase it in terms of minimum requirements. It just talks about requirements. Anyway, that's the MAT. Whizzing on to technical specifications, and again, not much change here. Substantively similar, but heavily slimmed down. Again, there's a preference for performance or functional characteristics in technical specifications over particular designs or models. And again, in fairly similar form to the current rules, UK standards can be referred to, but only if there's no internationally recognised standard. And equivalent standards from other states are allowed. So again, I don't think there's a huge amount of difference on technical specifications. So moving on to my next topic, supplier exclusion and debarment. I think this is a big area of change in the bill. So the government's taken on an opportunity to do a wide refresh of the rules on supplier exclusion. This pretty much came up between the Green Paper and the White Paper. I think the responses to the Green Paper indicated that there was quite a lot of uncertainty as to how the rules on supplier exclusion applied. So they've really taken a pen to this and done a refresh. So on exclusions, mandatory exclusions, we've got a rationalised and expanded list of offences leading to mandatory exclusion. I've kind of listed them on that slide. They're all very bad things. But the list that we had previously was a bit incoherent and didn't cover some things. I think one of the things that struck me, both on the particularly on the exclusion side, is they've added in some competition infringements. So cartel offence, well, that's pretty rare, cartel offence, but cartel fines, if you've been fined for a cartel in the UK or abroad, that triggers a mandatory exclusion. There are also mandatory exclusions for failure to provide information about exclusion grounds. And there's acting improperly in relation to a public contract gaining an unfair advantage, where exclusion is the only way to remedy that unfair advantage. So they've kind of toughened up the rules on improper behaviour. Yes? Sorry.
How far back is supposed to go?
I was coming on to that. Yeah, there's normally a 5-year limit. There is some. Generally, there's a 5-year limit. Some things have a 3-year limit, and some of it, in a sense, will be retrospective, and some of it will only apply when the act comes into force. I think if it's in relation to offences committed, it will only be offences prospectively. But it is quite a toughening up, I think, of the mandatory exclusion list. And I think the inclusion of cartel fines, I'll come on to another factor about that, and in terms of where you have sort of international groups. Oh, sorry.
What is the acting improperly?
Well, it acting improperly means trying to secure an unfair advantage. So there's a test of gaining an unfair advantage. So if you act improperly but don't gain an unfair advantage, you can't be excluded. So coming on to, if I just flick on to excludable, i.e. discretionary exclusion. So what they've said is, if you look at the sort of the second last line there, acting improperly in relation to the award of a contract, thereby gaining an unfair advantage, is a ground of discretionary exclusion. But they would then have to sort of investigate that with the supplier, and if they think that that can't be remedied other than by exclusion, then it, as it were, flips over into mandatory exclusion. But they don't really explain what gaining an unfair advantage actually is. And I think trying to get information improperly, as it were, about a procurement through existing relationships, I think that's probably what they have in mind. But it's also quite a tricky test, possibly, for authorities to apply, because they do have to make a judgment over whether an unfair advantage has been gained. How's that?
One of the questions that I had on the previous slide was this, that, for example, could be interbank region. Are they just corporate level offences, or if the director of the company is guilty of on-site, that looks good?
So coming on to so most grounds apply where a connected person is also guilty of the offence or misconduct. So that includes ultimate beneficial owners, directors, parent subsidiaries, and it's international. So going back to some of these breaches, we've got, I'm thinking of things like competition breaches. If you have a UK subsidiary and you have a parent or a sister company that's been fined, say, by the European Commission for engaging in a cartel within the relevant time period, potentially that's the exclusion circumstance. So, I think some of these tests for exclusion and debarment are going to be, I think, suppliers are going to have to look quite carefully at their what's going on in their corporate group, and make sure any sort of potential grounds for exclusion have been identified. So these are discretionary grounds. Again, many of the same grounds like insolvency and so on. But they've added serious labour misconduct, environmental offences, expanded the scope for exclusion on the grounds of prior poor performance. This is an old government chestnut. And so breach of a prior public contract leading to termination, poor performance, where the supplier's been given an opportunity to remedy and it hasn't, and also applies to equivalent contracts outside the UK. As I mentioned, in this case, non-cartel competition infringements. So that could be an abuse of a dominant position, it could be another type of competition infringement. And again, acting improperly in relation to the award of a public contract. And also, just sort of stuck on the bottom there, threat to national security, which is again a hot topic in government at the moment. National security exclusions on the ground of national security have been pretty rare, in my experience, under the EU rules. It was always possible, but sort of, I think, felt to be difficult. And now there's a much broader scope for exclusions on the ground of national security. So, as I said, generally it's a 5-year time limit. You need to check in relation to each offence whether it's a 5-year or 3-year, generally 5-year. It applies to equivalent offences and misconduct overseas. And as I was saying, it's connected persons, offences by connected persons also called. But we still have so-called self-cleaning rights. Suppliers must be given a reasonable opportunity to make representations as to how they've remedied the whatever the offence is or the misconduct. And lastly, the government's entitled to maintain a central debarment list of suppliers who've been excluded. there are obviously rights to appeal that if you're threatened with or actually put on a debarment list. But this is a significant toughening up, I think, of the rules on supplier exclusion and debarment, and I think will need to be looked at very carefully, both by authorities and utilities and by suppliers. Oh, sorry, are there any more questions on that?
Is that in response to some from the current regime, lots of contracts are being won by dodgy companies, or why is there been such a move to tighten in response to anything?
I think there's that's a good question. I mean, most of the problems with government contracts are about poor performance, and actually, expanding scope for exclusion for poor performance, but that's only in the discretionary side. Just because someone's performed poorly once doesn't mean that they're sort of banned forever. Excuse me. So, as far as central debarment is concerned, yeah, it is a good question. I'm really not aware of people bidding for contracts where they should have been excluded but were not able to be excluded.
It's not historical frustration over many years, in my experience. Ministers saying, why can't we kick out this rotten IT firm who failed to build this new system?
Yes.
And not only can't we not kick them out, they're bidding for our new contracts and you're telling me they're winning those.
Yes.
And that's the frustration.
Yeah.
The problem is if you dig into anything like that,
yeah.
20 reasons why it's the department's fault.
What I can't remember, and I'll have to check now looking at the bill, is whether the debarment list applies if it's just a poor performance issue or whether it's more of a sort of bad conduct issue.
Your list including homicide is slightly beyond poor IT contract performance.
Yeah, no, okay. So, thanks, Sam.
You could look at something like the Fujitsu and Procurement Bill contract, and I think that's been out for Fujitsu.
So, no, so that is right. So there's, first of all, there's got to be an investigation. And the minister has to be satisfied that the supplier is an excluded, i.e. mandatory excluded supplier, or an excludable supplier. And then they get put on the list. So
That's a work for lawyers.
yeah. So yes, I mean, I think it is aimed at that sort of historic, grumpiness about sort of the same old people performing badly, rightly or wrongly, whether that's true or not. But
just after this whole things working, are there rules around what has to be accepted as
evidence? Not really, I don't think. I mean, obviously for a debarment, there has to be a proper investigation. I mean, it's a pretty serious matter. So there would have to be a proper investigation of it. Evidence would have to be taken into account. There's a right of appeal. I think so the bill says contracting authority may have regard to evidence that the supplier has taken the circumstances seriously, steps that the supplier, associated person or connected person has taken to prevent them occurring again, commitments or provision of information to allow verification or monitoring of the steps, the time, and any other evidence. So sort of kind of not very surprising list of things that you might sort of expect to be taken into account, and anything else.
Nick?
Yes.
Excuse me, sorry. Perhaps a bit controversial, but the sense I'm getting here, to be corrected, is that this feels quite woolly, quite a watering down compared to what we have, quite subject to interpretation. Am I on the wrong track here, or?
I don't. Maybe I didn't mean to suggest that. Did you mean specifically in relation to supplier debarment?
No. In general, compared to the current.
I think there's some of that. I think there's some of, they've simplified, but in simplifying, they've actually removed quite a lot of sort of fairly familiar language, which we sort of knew how it worked. So we're left with the kind of questions of, well, how is this supposed to work? And then, of course, quite a lot of things get kicked off into regulations, which we haven't seen yet. What the notices are going to contain, we don't know. And I think there's quite a lot of reinventing, probably unnecessary reinventing of the language, which is just going to leave room for more debate. And then we don't have any EU case law to rely on to interpret it. So I think there is an element of that. I think on this front, on supplier exclusion, it's sort of fairly clear, is they've actually clarified it in important ways. But, we already had some quite strong rules on supplier exclusion. It's just that they weren't necessarily applied as vigorously as the government would have liked, perhaps.
Sorry, one more question.
Yeah.
Sorry. Just on the national security exclusion.
Yeah.
There's been an attempt to align the definition of national security in this bill with other definitions of national security and other government legislation.
You mean the National Security and Investment
For
Act?
example, yeah.
I mean, first of all, they didn't define national security. So national security is what the minister thinks it is at the time. But it is interesting that national security is particularly carved out, both in terms of exemptions and in terms of exclusion, because it was always my impression was, on occasions when we've looked at cases involving national security or defence issues, that if you looked at the European treaties, it says national security is within the exclusive scope of power of member states. So in theory, member states could say it's national security. Sorry, treaties don't apply. But the government, in my experience, was always really reluctant to do that because ultimately you could get challenged before the ECJ. Admittedly, with a sort of very wide margin of appreciation. Now there's none of that. So you've basically got these broad ability to exclude contracts and suppliers on the grounds of national security. And who's really going to challenge it? The government says, sorry, it's national security. So I think there is going to be more scope for that. But I haven't really aligned the definition as such because they don't want to define what national security means. Frameworks, everybody's favourite topic. Frameworks, more leeway for frameworks for longer than 4 years. If the nature of the goods and services justify it. At the moment, it's allowed for more than 4 years if it's exceptional circumstances. I've seen lots of frameworks that are more than 4 years and people have found exceptional circumstances. So I'm not sure that's going to make massive difference. Defence and security and public sector utilities. The maximum term is 8 years of frameworks. They've simplified the mechanics for calling off contracts, I think. Competitive selection must be used unless the framework sets out the core terms of the call-off. So at the moment, the rules say if the framework sets out all the terms of the call-off contract, you can do a direct award under the framework. Now it's talking about the core terms. I don't think that's a massive difference in practice because in practice, many frameworks do not set out all the terms and they still allow direct awards and they probably does set out the core terms. An important, perhaps, change is the introduction of open frameworks where suppliers can join during the term, which have a maximum term of 8 years for a multi-supplier framework and 4 years for a single supplier framework, and there has to be a couple of opportunities for new suppliers to join during the term. I have to say I find this bit of the drafting book extremely complicated to understand, but I think that is the intention that you have.
Is this to replace what we now have in the DPS?
No. This is a new thing coming onto the DPS replacement. So yeah, so frameworks are going to be. I think there's going to be more flexibility, longer terms, open frameworks if anyone can understand what they've written in the bill. Dynamic markets. That's the DPS, dynamic purchasing system plus, as they call it. So it's an evolution of a dynamic purchasing system applicable to any goods or services, not just those that are commonly purchased, as it says in the current regulations. Suppliers must be allowed to apply throughout the term of the market. And competitive tendering procedures, other than open procedures, may provide for the exclusion of suppliers who are not members of a particular dynamic market. In other words, it's like in the utility sector, you have qualification systems. I think it's a bit like a utilities qualification system. You're sort of pre-qualified through the dynamic market, and then the tender can be limited to those suppliers. For utilities, they don't have to publish a tender notice. They can just send a notice to members of the market instead, which I think is similar to the position for qualification systems under the current utilities rules. So essentially what we have is a sort of alignment of the public sector with the utilities rules in relation to qualification systems. So I suspect this might become quite a big thing when the bill comes an act. Sort of rattling on, direct award. Again, not massive change, similar narrow grounds to the current rules. Award to a single supplier, for example, for reasons of IPR or technical reasons where there are no reasonable alternatives. Very important, sometimes in the pharma sector, for branded medicines, but also elsewhere. Extreme and unavoidable urgency. All those things are still there. But there are some new direct award grounds for contracts that are necessary to protect human, animal, or plant life, or necessary to protect public order or safety, which is the COVID carve-out. So the government's giving itself the power, sort of specifying regulations to exempt contracts if we have another pandemic or significant event like that. User choice contracts in the context of social care services, where it's a matter of individual choice, they're carved out as well. And certain contracts in the field of defence and security. Really important change, the last point on this slide. As many of you may know, at the moment, if you make a direct award without competition, you have the option to put up a so-called voluntary ex-ante transparency notice, which sets out your reasonings for why you're doing that, and then you apply a standstill period, and that then protects that contract from being declared ineffective if it turns out that the justification was invalid. That's going to become mandatory. So transparency, well, I think either certainly a transparency notice, possibly also a contract award notice, and a standstill period before making a direct award. So that's a sort of an additional bit of, regulation that will apply in the case of direct awards and not an option anymore. Transparency. So the green paper, rather hopefully promised, embedding transparency by default through the commercial life cycle from planning through procurement, contract award, performance and completion. What we have in the bill, on the other hand, I've already talked about the slight downgrading of transparency as an objective. We have lots of new notice and publication requirements. There's a so-called Tell Us Once supplier registration service, and then a centralized digital platform. I'm not going to talk really about those last 2 points, but I will talk a bit about some notices. Now, we go on a bit about this. I'll try not to. Notices. Got 3 slides on notices. I'm not going to go through every single one, but just to illustrate that there are quite a lot of notices. So pre-tender notices, we've got planned procurement notice, which I think is a bit like a PIN, optional. Preliminary market engagement notice. And then pipeline notice, sort of does what it says on the tin. That's for where an authority expects to spend more than 100 million in the coming financial year. It's got to set out what its pipeline is. A tender notice, that's the contract notice. That's the sort of the main one. Obviously, dynamic market notices, intending to establish a dynamic market, modifying it or ceasing to operate. And then a below threshold tender notice. I haven't talked about below threshold contracts, but there's no obligation to advertise below threshold contracts. But if you do, you have to use a below threshold tender notice. Then we've got post-tender notices, we've got a transparency notice, which is where the authority or utility is planning to do a direct award. A contract award notice, now those of you who are familiar with this know that a contract award notice under the current rules is what you publish after you've entered into the contract. A contract award notice under the bill is what you send to bidders before you enter into a contract, just to confuse everybody. Then after you've entered into the contract, there's a contract details notice, which was a contract award notice, if that all makes sense. So there's a lot of scope for confusion about the names. And then publication of contracts. All contracts over £5 million have to be published with appropriate redactions. In life notices, so it goes on. This is the last slide on notices, by the way. Again, contracts over £5 million, authorities have to publish key performance indicators, but it doesn't apply to a whole host of things, frameworks, utilities, private utilities, concessions, and so on. Information about breaches and failure to perform the contract. Information about compliance with payments obligations. And then another important thing, which I'll come on to, is a contract change notice. So when an authority proposes to amend a contract or modify a contract, again, under the current rules, it's optional whether you put up a voluntary ex-ante transparent notice. Under the bill, it will be mandatory to put up a contract change notice. So that is likely to bring to the surface many more contract changes which previously have gone under the radar. Then modified contracts have to be published, and contract termination notices. So a whole host of notices, and this is the idea of, like, you know, getting rid of the process-driven bureaucracy. We now have many more notices than we had before, and many more obligations to publish notices. So what do they all need to contain? Well, mostly it doesn't actually say in the bill, and it's all to be specified in regulations under what is currently like Section 93. It might change once the bill becomes an act. So that's a bit of a blank page at the moment.
Where are these notices to be published?
On the tenders, find a tender thing. Yeah.
Can I just ask,
Yes.
what's the difference between the preliminary market engagement and the other planned procurement notice?
No, a planned procurement notice is like, I think a PIN
Yeah.
is used in a number of different ways, isn't it? Sometimes you'd use a PIN, because there's only a PIN. You'd use a PIN sometimes to say, well, we're going to do some pre-market engagement before going out to tender. A planned procurement notice is saying, we are going out to tender for these contracts in the next year. A preliminary market engagement notice is a notice which says, we want to do some market engagement to find out what the market is before we even.
Right, so the planned procurement would be what
Yes.
which you can use to plot timescales.
Yes, exactly. Those probably should be the other way around on that slide, because the preliminary market engagement possibly precedes the planned procurement.
Because it's kind of like how I use pins mostly, just
Yeah.
for market engagement.
Yeah, I think that's quite common, but I think this has separated it out. So you have an extra notice to think about. Modifying public contracts, which is a topic of, in my experience anyway, great practical importance, because any contract of any duration typically needs to be modified at some point during its term, or modifications come up. On the whole, the bill basically replicates the current set of permitted contract modifications, which those of you familiar with the terminology is Regulation 72, the public contracts regulations, and equivalents and the others. So we have the sort of the usual kinds of permitted modification. They've added where a known risk materialises, which is I find a slightly odd thing. But again, I think they're trying to think of. It's sort of like the Donald Rumsfeld known unknowns. You know, if a known unknown arises, something you've kind of predicted as a possible risk, but you haven't been able to provide for somehow in the contract, then you can modify the contract to take account of that risk. I find it quite a puzzling bit of drafting, and I'm not entirely sure what the policy concern behind it is. But it's a new form of permitted modification. And again, in the light of COVID, modifications necessary to protect health, public order and safety. There's been some clarification and simplification of the wording, but I think, again, some possible traps. And I'll give you an example of something on this subject, which kind of illustrates, I think, some of the things I've been saying about the way that they've changed the wording in ways which doesn't seem very helpful. So one of the current rules which allows contract modification is where you have universal or partial succession into the position of the initial contractor following corporate restructuring, including takeover, merger, acquisition, insolvency of another economic operator. It's the provision which allows you to change a contractor in a contract without going through a further tender because there's been some sort of asset sale, business sale, corporate restructuring, insolvency, some legitimate corporate activity, which has led to the need to change the name on the contract, essentially. And what the government has said in the bill is it just refers to you can change the contract in the case of corporate restructuring or similar. Now, to my mind, corporate restructuring or similar doesn't necessarily include an insolvency. It doesn't necessarily include a merger. It could be a much narrower test, but for some reason they've chosen not to adopt the wording that we have in the current regulations. I don't understand that, but that's fairly typical. It's a typical example of the way they've changed the wording to make it simpler, but perhaps possibly they've lost something along the way. More interestingly, perhaps, non-substantial modifications. This, I think, is an important bit of the bill. So an important question that we come across a lot is if a contract is being modified, is that a substantial modification? And there are three tests. There are tests. Does the modification, would it have affected the procurement in some way? Would it shift the economic balance in favour of the contractor? Would it considerably increase the scope, or would it result in an overall different contract? And that's been sort of, I think, improved and changed a bit. So first of all, they've said an increase or decrease of less than 10% of the contract term is a non-substantial modification. That, I think, is going to have a really, if you've got a 20-year contract, you can extend it for 2 years without that being considered to be a substantial modification. They've dropped the requirement to show the modification would have had an impact on the original procurement, which is, I think, helpful, because if anyone's come across that was a difficult test to apply. And they've also added the word material in relation to economic balance. So any change in the economic balance of the contract has to be a material one. That was probably implicit in what we have at the moment, but it wasn't expressed. And as I've said, a contract change notice must be published before making a modification, which should bring to the surface many more contract modifications than previously was the case. Okay, coming to the end of my. Sorry, I've been rattling through that a bit quickly. Has anyone got any kind of questions or observations on any of the last bits? I just want to say sort of a few words about, I've got the last few things, some light touch contracts, a very brief word about NHS procurement, and then a bit about private utilities. So under the current rules, we have something called the light touch regime for health, social, other kinds of services where it's thought that there is less likely to be interest from suppliers outside, in the case of the EU, or from outside the country in question. And the government had proposed to get rid of the light touch regime entirely, but they brought that back in following the comments on the consultation on the green paper. They haven't said exactly what's going to be covered by the so-called new light touch regime or light touch contracts, because they're going to set out in regulations what those are, having regard to whether suppliers outside the UK are likely to want the contract, whether the services are supplied for the benefit of individuals or communities, and where proximity between the supplier and the recipient is necessary or expedient for the effective and efficient supply of the services. So, I mean, that sort of broadly speaking describes what we have currently in the light touch regime, but they haven't kind of come up with a list of services. So what's the difference for light touch contracts? The whole list of things here. I mean, more flexibility to modify them. They can be reserved. There's no minimum periods. There's no limit on duration. No obligation to apply a standstill. I've already mentioned various limitations on the notice provisions and so on, which apply to light touch contracts. So a lower level of regulation. I mean, the only way to find it out is to get a PDF of the bill and put light touch in the search thing, and then go through all the places where it says this does not apply to a light touch contract, this does not apply. But that's a category of contracts which is yet to be defined, which has some lower levels of regulation. Very briefly on NHS procurement, because it doesn't say very much about NHS at all in the bill. In principle, NHS procurement, whether that's healthcare services or medicines of different kinds or supplies of medical devices, that's all in principle covered by the bill. But the government has the power to disapply it in the case of contracts covered by the health procurement rules. So we don't really know at this stage how much NHS procurement will be covered by its own special regime. I know there's some people who are interested in that, its own special regime, or whether it will be covered by the general regime. I would suspect that for a lot of cases, the health services type procurement probably will be put into its own special regime, and health supplies of different kinds will probably be kept in the main regime. But that's my supposition on that. So lastly, just to wrap up this sort of overview before the break, private utilities. I'm not sure we have any private utilities here, but again, the government there was some concern expressed during the consultation on the Green Paper that by amalgamating all the regulations, utilities, which had a lower level of regulation before, would be sort of have a higher level of regulation under the bill. So again, there's a whole load of carve-outs for private utilities, which I won't go through in detail, but they obviously don't have to have regard to the national procurement policy, no maximum term, reduced notice and transparency, no mandatory standstill. They can allow all those crooks and criminals to participate if they want to, and they're not subject to procurement investigations, which Steve will talk about after the coffee break. So it's now bang on 11:30. So does anyone else have any kind of questions or burning things to ask? Or
just a quick one, maybe. Has there been any discussion or commentary sort of about what might happen in the wake of the bill to existing approaches to government contracting? Sort of, will there be changes to the approach to G-Cloud or CCS frameworks and model services? Do we expect kind of major refresh there?
I don't think so. I mean, I think it's a sort of a resetting of the sort of underpinning rules. But I don't think that, procurement practice on the ground is going to change massively. And that's partly a function of the fact that the current procurement rules don't really say much about how you run a procurement. They say certain things have to happen, but a lot of the detail of how procurements are run is all a matter of procurement practice and, in a sense, the practical implementation of equal treatment. How do we ensure equal treatment? Well, we have to do this, that, and the other. And that's the sort of thing that's developed over time. I think, things like the G-Cloud already were a little bit at the boundaries, shall we say, of what was permissible potentially under the frameworks. I think that might be a little bit easier to get in under the open framework rules or the dynamic market rules, but they'll still do the same thing. They'll just have a sort of slightly different legal cover for it. I think overall that will be quite similar. What I think one of the things I'm a little bit concerned about is transparency. I think there's a lot of, as I said, there's a lot of notices, but we don't know what they're going to contain. and we don't have this kind of thread of transparency running through this sort of really sort of hard-edged thread of transparency that we have in the current rules, which basically say authorities have to, disclose everything about how they're going to run tenders. And the bill is a bit kind of vague and woolly to your point about what has to be disclosed. I'm pretty sure that it's fairly unlikely that most well-advised authorities will do kind of silly things like not disclose their criteria or, But I don't exclude the possibility that people might try to find ways of doing that, because the bill has muddied the waters in that respect. But as I said, I don't think, others think, I don't think there's likely to be massive changes in the way procurements actually run. Sorry, did you have a question? No, sorry.
And I mean, commercial confidentiality still trumps transparency.
Yes, it does. Yes.
So an FOI will still apply.
Yes. Yes. Yes.
So I just think there's going to be for procurement.
Yeah. So all this stuff about, publication of contracts, for example, that's all subject to obviously commercial confidentiality, so there's redactions. But then we have publication of key performance indicators for bigger contracts, so those will have to be published. But then they'll also have to publish information about failure to perform, and that I think is going to be interesting on the commercial confidentiality side.
Couldn't you say I can't publish the KPIs because they're commercially confidential?
Well, no. Well, I don't think the bill says that you can't publish the KPIs because they're commercially confidential. So I think there are some interesting questions about that. And there is a sort of certain amount of naming and shaming that's expected in the bill. So obviously things like pricing information, that sort of information is to be commercially sensitive, but the fact that someone has not performed a contract, I think, is likely to be liable to be made public.
So that's going to drive meaningless KPIs.
Yes, I think, yes. Yes, it might. Easy to hit. Yeah. Yeah, that's probably right. Yeah.
Do we, when we say KPIs here, do we mean things like KPIs that you see in a commercial contract or service levels?
I'm not sure if it, well, that's a good question. Let me just have a look at that.
I think the intention is to get the stuff. So
yeah.
If you're the company that delivers passports, what percentage of passports are you delivering?
Yeah, it doesn't say. It doesn't say very much. It says before entering into a public contract with an estimated value of more than £5 million, a contracting authority must set and publish at least 3 key performance indicators in respect of the contract. But that doesn't apply if the authority considers that the supplier's performance could not appropriately be assessed by reference to key performance indicators, whatever that means. And then it says a key performance indicator is a factor or measure against which a supplier's performance of a contract can be assessed during the life cycle of the contract. So it's very open. But yes, I mean that could be it could be an area where sort of very bland KPIs are put in place to try and minimise any kind of commercial sensitivity.
Do you understand the information about payment thing right? That if I have a big contract and call off a lot of statement of work underneath, but every time we spend more than 30k on a statement of work, we have to send out another notice, because that would be not simplifying things, that would be not for it.
Yeah, there's quite a bit of that. I'll have to check that specific point, but yes, I mean, there are payment terms, and the notice setting out authorities' compliance with payment terms. It doesn't apply to private utilities, but it would apply to public undertakings.
So is that for every payment, or is that not sort of usage?
We're now posing the question, how will the bill impact procurement litigation, which sounds worryingly to me like I'm required to make some predictions about the future, which, having spent £20 of my kids' inheritance betting on Belgium to win the World Cup. I wouldn't set too much forensic value on what I'm about to say in answering this question. But to the extent we can, we will have a look at, effectively the current regime and then what the new regime looks like and see the extent to which there is change, if any. So I don't know if anyone in the room has had the pleasure of dealing with procurement litigation before, but if you have, I suspect you'll have a view on its limitations and some of the unique features of it. At a talk Nick and I attended quite recently, one of our favoured King's Counsel for litigation, she described the current regime as unpredictable, expensive and potentially pointless, which as a procurement litigator is not something I really want to put on my business cards. But that is the perception of the current regime, and so what I expect the drafts people in the Cabinet Office and elsewhere, when they went to sit down to look at the bill, litigation would have been one of their focus areas, because particularly for challenging parties, i.e. unsuccessful bidders, etc., there has been a lot of frustration that it doesn't deliver, and I'm sure equally on the government side there are plenty of frustrations as well about how it works. So the current regime had its problems that everyone acknowledged. What's to expect in the new bill, it's hard to say, because one of the things that's sort of been notable about the process is that lots of ideas have been proposed and then not really followed through. So there's lots of ideas, some of which I've listed there, which are effectively have been in the green paper stage and have not made it through to the bill. In particular, I think to point out the sort of proposed tribunal system, which I think a lot of professionals at least were interested in, because that's a specialist mechanism to resolve disputes, ideally a bit cheaper and a bit quicker than the court process. And having raised that possibility and got a lot of lawyers excited about a new place we could bring claims, that's now gone. The flip has now been on to effectively promising form of the civil procedure rules, which, in case you don't know, that's basically the court rules that apply to all types of litigation, not just procurement disputes. And so the idea that they've sort of gone from the one hand from a specialist tribunal now into just effectively promising to amend the court rules generally sort of suggests there might have been a bit of a fudge here, or a loss of resolve or bottle. And I think the overall conclusion, spoiler alert, is that the essential fabrics of the regime appear to have been preserved in the bill, and so the change may not be as seismic as perhaps people were thinking it might be. The sort of launch pad for litigation, as a starting position, if you will, is the award notice and then the accompanying standstill period for in the event of a challenge. The current regime is the one that's in Regulation 86 of the PCR, or the equivalent, and that effectively requires an award decision notification to be given, including the crest and information enabling all sides to understand the decision. Now, one thing Nick and I have noticed about that regime, having litigated under it for the last 5 years or so, is there is no prescribed form for that notice, and they come in all shapes and sizes, and unsurprisingly, some people are better at drafting them than others, and so you get a mixture of all sorts in the regime currently. And the other key point to note about the current regime is this 10-day standstill period, which isn't limited to working days, and so depending on when the notification comes out, can lead to some long weekends or indeed bank holidays. So that's the current regime, which you may fondly know of or not, and sort of a sign of how difficult this issue is, and I guess how important it is as to how the notification regime and the accompanying standstill should work. It is shown by the fact that during the bill's process, the goalposts have moved along the way, and the government's position has effectively shifted, and it's reasonable to conclude that they've got it slightly, and it's in the too difficult box paradox, really. You sort of started off with a green paper position, trying to really pare back the system, remove the need to do the individual debrief letters, and now we've gone almost full circle into a position where there must be the new style of award notice that he was talking about published before entering into the contract, and then a provision of evaluation documents is what the the white paper in 2021 said. To basically replace the individual debrief letters and instead provide the evaluation documents. Now, query what evaluation documents means, but you would assume that includes quite a bit of information about precisely what the process went on, how you came out of it. But in fact, under the bill, we've sort of slightly moved again, and we've now got a position where you must publish a contract award notice before the contract is awarded in the provisions that Nick mentioned. But then before that step, you also have to, provide suppliers who submitted, the qualifying tender with an assessment summary, but not the evaluation documents. So effectively, a summary of, what the decision taken was against what information, etc. But with, as it stands at the moment, not a great deal of prescription as to what is supposed to be within and without that regime. And at the moment, there is no ability for the government to sort of specify in more detail what that involves. So I think you have to be a mercenary litigator in the field to look at that and think this is going to be ripe for some problems. If you've got an obligation, statutory obligation to provide an assessment summary, but no proper guidance as to what that involves, then clearly your well remunerated lawyers will have a field day arguing about it. So that is something that jumps out. And then the change in the standstill, reflecting obviously the work-life balance that we all enjoy post-COVID, they've now changed it to 8 working days instead of 10 normal days. So depending on whether it falls in a particular month or what day they serve it, I guess that may buy an extra day. But the reality is that I think that bidders are going to be in a similar position than they are, as they are under the current regime. They're going to be short on time and short on information and under pressure to make a decision about whether a challenge should be made or not. You guys probably know better than me, but it always seems to me on my side of the fence that unsuccessful bidders really want to have sufficient information and understanding to make a decision on whether a challenge is relevant or worth considering at all. They need to understand the basis of the decision made. You may agree or disagree with it, but you at least need to be in that position to understand. And I think one of the things that Nick and I come across when these cases come in is that far too often bidders are with all the best intentions, are not in a position to understand the decision made because the information provided and the limited time and the limited disclosure obligations, etc. So at the moment, there's no suggestion that the new regime is going to cure a lot of those ills. We're going to be, I think, in a similar scramble trying to understand what's happened and how to do it. The next thing to consider is the issue of automatic suspension on the award of the contract. So this is the injunctive effect on entering into a contract in the event of a challenge, and it's effectively a losing bidder or a challenger's biggest weapon at the outset of the ability to effectively require or restrain the authority from awarding the contract. And the current regime effectively works on the basis of the usual position for injunctions in law, which you may or may not know, but is effectively a test about whether damages are an adequate remedy for a party that's been wronged, i.e. whether money can compensate what they've lost, rather than something intangible that can only ever be restrained by physically stopping what's going to happen. And there's been a very interesting recent case on this issue under the current regime in relation to the lottery contract, so Camelot against the Gambling Commission. And if ever, as a lawyer for challengers, you wanted sort of paradigm case of a unique contract that couldn't be compensation damages. I would have thought running the lottery for 28 years as your sole brand with all of the uniqueness that attaches to that contract, you would have thought that if ever there is going to be a justification for the suspension, that is it. But they were actually unsuccessful in maintaining the suspension on that case. So because of effectively a much more rudimentary balancing of damages and also a big public interest push on, well, the lottery obviously supplies provides for a lot of good causes, and there's effectively an open-ended risk in not maintaining or maintaining the suspension. So the current regime, I think, has effectively been tilted very much in favour of the government side of the coin, or the winning bidder side of the coin in the automatic suspension. Although it tends to get in place, it also tends to be lifted quite quickly. And so whether the new regime can change that is going to be quite important for losing bidders. And I think here there does look to be a move for change. That they've the bill expressly reframes the test away from this kind of the normal adequacy of damages position into a three-stage test involving public interest, the interest of suppliers, and any other matters that the court considers appropriate. And the first one of those is probably the most interesting, that's the public interest. So here you have an obvious public interest in making sure that procurements are run properly, that the law is upheld, the system is observed, and then equally you have a true public interest in making sure that the contract is not unduly delayed and that people using the services are not impinged. And so I think that first test is going to be the battleground, and what you're going to have is a balance between the interest of getting the law right and the interest of the actual performance on the ground, and whether it will make any difference will obviously be tested in court in due course. But I think the answer is that it will. Effectively, the new regime gives a freer position to the court and look at everything around and say, well, these are my factors that I'm going to take into account, and it's no longer just a question of damages versus uniqueness of contract. Instead, actually, there's no constraint here. What is the best thing to do in the circumstances? And I think even under the old regime, particularly with some of the more recent judges in the courts, the TCC courts, which are the courts which hear these cases, Nick and I've experienced that you will even get then quite a fact-sensitive approach to these issues. You'll get judges who will look at on a very human level of the the nature of the contract, what is actually at stake here, health or defence or whatever, and take a quite specific and bespoke approach. And I think the new regime effectively makes that even easier. And that does seem to be a good thing in the sense that each case obviously in each contract exists on its own merits and its own facts, and that's important. I think the key battleground is still going to be delaying the services versus can you do anything different, and is there anything particularly that justifies doing so. But I think in the context of a broader playing field. The other sort of final thing to say about automatic suspension, from a practical point of view, if you're thinking about it as a challenger, or to be honest, if you're the incumbent on a winning bid in particular, is that Nick and I have had some successes on cases where we've sort of effectively agreed a sort of holding position on that. So instead of losing out, we've managed to agree that maybe if an incumbent has won and we're challenging, that they can have a year to allow the proceedings to carry on and that kind of thing. So you're always trying to think about whether there's a practical solution to get around the problem. One sort of other point not on the slides about the automatic suspension regime is to do with the undertaking in damages. So this is another thing that exists from general injunction law in English law. When you go for an injunction against somebody, you generally have to undertake to pay them compensation in the event that the injunction turns out to be wrongly granted, and that's part of the whole test that the court weighs up. And under the current PCR and equivalent regimes, there is effectively an automatic obligation to give an undertaking where you're seeking to have the automatic suspension put in place. That's now fallen away under the bill, so it will not be required every single time, and it may depend on the particular circumstance of the case. And that may make challenging more attractive in certain circumstances, depending on the type of contract and where, you know, particularly on enormous cases where the money is just so astronomical that the damages, you know, which is an issue, to be honest, on that Camelot case, the kind of downside of getting it wrong was so high that you couldn't, you know, how would you even frame an undertaking for restraining the lottery contract? Whereas now that's gone away, actually there is some more discretion there. So I think a freer regime on the automatic suspension, which, you know, maybe a good thing. Other remedies where we haven't got the automatic suspension or alongside it is the damages regime, and clearly, you know, when most cases that come across my desk come in, that is ultimately a prime concern for the claimant, because even in circumstances where you can get the automatic suspension, you can maintain it. The reality is that, you know, litigation is more often than not resolved by an agreement with one party paying the other some money, and so damages remains both an important principle for people to be entitled to claim, but also an important part of the overall commercial position when getting to a dispute about a procurement. The current position, almost I think uniquely in English law, is that damages are only available where there is a sufficiently serious breach, which is effectively an oddity arising out of EU law and, you know, effectively followed in the and laid down in the Supreme Court. And although you would have thought that those words sufficiently serious are pretty innocuous, and, you know, most commercial claimants who have lost money would be able to meet that hurdle, you do actually get absurd results from the current regime, including the Brace Yourself case, if you've heard about that, which was relatively recent, where effectively it was an incumbent who lost on a tender of their contract. It was established that there was a manifest error, established that it should have won and would have won had the manifest error not occurred, but somehow the court found that it wasn't sufficiently serious for the, you know, effectively for damages to be payable, which, you know, if you're in that position, you know, having been an incumbent, it must be pretty grieving to be in. Lots of fact-sensitive bits, but, you know, the judge's conclusion was that it was a single inadvertent mistake, and so therefore, you know, didn't meet the threshold test. And so that is a big flaw, or certainly a flaw in the current regime, and one that, you know, we're wary of when it comes up. That will now fall away under the new bill. That test will no longer be there. You know, obviously the law falling away as well, the kind of underlying reason for it will go on. But there will still be court discretions. This gets back to the point I was making before. You will still have human judges looking on a fact-sensitive basis at particular contracts, often which will have quite a lot of public importance about delivering services to the public, and you can expect those judges to take sort of quite fact-sensitive and quite, you know, human nature-based decisions, I think, and they will use their discretion to do that. Aside from damages, the other main remedy that people talk about in this, you know, in this sector is the declaration of ineffectiveness under the current regime, and that is effectively the principle that where the contract has been awarded, so it can't be stopped or suspended, but it shouldn't have been awarded, and show why the test is met, you can then effectively have the contract declared void under the PCR regulations that they stand at the moment. This has been traversed, I think, into what is called a set-aside order, which I think largely means the same thing, effectively stepping in after the event to, you know, undo the contract and set it aside. And there are four conditions for meeting that set-aside, which are put down. I won't read them all out. But, you know, as it stands, the declaration of ineffectiveness is quite a rare remedy. There are many reported cases on it. Certainly in our team, we've only come across it in terms of actual issued cases, you know, on a handful of occasions. It was never a common thing. It has been maintained. one sort of practical thing to be thinking about if you're in a position where you're ultimately seeking set aside is really about timing, because if you are suing in the High Court seeking this remedy and High Court proceedings, absent, a fast forward button will take 12, 18 months, longer in some cases, I have to admit. Then, really, if you're talking about a contract of 2 years or 3 years, you could be fighting for the ultimate Pyrrhic victory in declaring a contract set aside, at the exact moment in time when the authority has got to re-tender it. So that's something we've always got to be. And then final sort of, not quite specifically a remedy, but the final sort of point to note about the bill is a completely new issue about procurement investigations, which obviously sounds very exciting and interesting new opportunities. The basic issue is an appropriate authority, effectively meaning a minister or a government department in the devolved constituencies, can investigate an authority's compliance, presumably on referral from, a member of the public or a successful bidder, and then take forward their own investigation and make findings, and obviously issue recommendations and publish the results. And that sounds attractive on the face of it, particularly as a means of effectively getting somebody to investigate whether something has gone on for free rather than paying to litigate it. But interestingly, the relevant contracting authority does not include central government departments or the Welsh ministers, etc. So there's a slight feel that this may be to do with sort of supervising the shires, I think, in the sense that the government could investigate a local authority or perhaps an NHS trust or equivalent, but it doesn't actually apply to the main main government departments. I mean, obviously the regime hasn't started yet, so this is all sort of speculation on my part. But my feel is that, firstly, what are you going to have to do to persuade a government minister or equivalent to actually go ahead and do an investigation like this properly? Is it, realistically, I guess it's going to have to be in a pretty high profile and, interesting or significant case. I don't suppose that, it's going to be a great mechanism for resolving sort of a one-off commercial grievance about that process. And then the other sort of point is, a more general one from my experience as commercial litigator generally, is that where sort of government investigation bodies exist alongside, effectively a means of private enforcement via litigation in particular, is that, you can never underestimate how long the government will take to investigating body will take to look at something, and how much persuading as a whether as an interested third party or as a genuinely affected individual or company, how much effort it will take to get them interested in it. Whether it's in equivalent fields, I don't know, with police in relation to fraud claim or similar. There just is never, on paper it always looks great where you can refer to this public body and they've got then the public law duties to pursue it, but in practice remains to be seen whether how they're funded, this body will have more appetite than perhaps some of their equivalents. So that's a whistle-stop tour of the new bill as it applies to litigation. Is there any sort of specific questions on that?
Just a detail, it says it doesn't include central government departments, does it include agencies and NDPBs?
I don't know the answer to that. Yes, please.
It's hard to see what you couldn't do, why you couldn't do that anyway, isn't it, without it being in the bill? Apart from maybe the duty to have regard to the recommendations. Couldn't government already carry out an investigation?
I think that's right. So I suppose in wanted to codify it, might encourage them to do it.
They have the public office, what used to be called mystery shopper, and now it's called something else. Who can go and ask local authorities why they're not paying suppliers or something. But I think that last point, they can't sort of demand that they do anything.
That's true. I mean, they do have a unit which does these sort of investigations, and they have had for a while. I think this is just putting it on a statutory footing, and obviously sort of creating more duty, albeit have regard duty to the recommendations But yeah, I mean, it is true something they could do anyway. On your question, the answer is that no, it's the Minister of the Crown or Government Department, so they can investigate agencies and government.
Litigation side.
Sorry, quick question, if I may. Crystal ball time. So based on your football predictions, do you think there will be more or less litigation going forward?
I think we could say with confidence that when they change the law, there is always an uptick in litigation to start off with. So definitely in the short term, I think more people will have, as we during Nick's talk, we heard the paring back of language, the removing of some quite well-established principles, the removing of EU law, that must leave a vacuum within which people will bring challenges. So more definitely in the short term. In the medium term, hard to know. The regime in principle seems similar to the current one. So I was going to say hope, but obviously I shouldn't hope for litigation, but I would hope no less than the current. So, obviously, well, many test cases that I can run. New principles. I think that's. Sorry, yeah.
Maybe for both of you. So I want to questions.
I thought we've already identified my ignorance. And
it's a more general question. Maybe something in the room as well. It is the whole thing. This is supposed to be said at the beginning. Freeing up the procurement profession to do wonderful creative things. Do you think, as people in the room who are active in procurement, are people going to invent wonderful new processes involving, best and final offers, interviews with suppliers, new bits of process we haven't even thought of, or are they going to follow Cabinet Office guidelines? Because Cabinet Office is going to come out with a few model procedures all based on that. And my feeling is, it won't be like innovation because people will be scared of doing the wrong thing. I've only talked to one head of procurement who said, "Oh yeah, I'm going to go off and invent some new ways of doing things."
I personally agree with that. I mean, I don't think it's massively helpful to have such a kind of open-ended approach towards how you actually run a procedure. I think people do like to have some structure. I think, if you've got, I talked about the sort of the principles, but there's still a hard-edged obligation to treat suppliers the same. Equal treatment is still there. So you still want to sort of behave in the way that's essentially you've always behaved, and that has driven a lot of the way procurement procedures have developed. I mean, I always used to say that what was my job in procurement, especially when advising authorities and utility buyers, it's really the practical implementation of the equal treatment rule and the transparency rule, because the regulations don't really say much. They've got a few things you have to do, a few waiting periods and a few bits and bobs, but most of it's about how do you actually implement that, and that's still there. So I think creativity and innovation, any kind of innovations I sort of cross my mind are sort of backwards ones. Can we go back to a kind of world where we were less transparent? We made decisions without telling people what our rules and criteria were. I have a concern that sort of thing might start to seep back in, but then I think we get into potential challenges because clearly there is a thread of transparency and so on that runs through it. Again, a lot of stuff about what suppliers actually have to say, tell bidders, is to be revealed in these regulations. So I agree with you generally that I don't think it's innovation.
And if there was a lot of innovation, it confused the hell out of suppliers because they'll find every tender thing. Exactly, as a different process. Exactly, it's a frequent exactly. There's loads of tensions. I mean, on the one hand, they've got an overriding duty to think about SMEs. And I presume if you're an SME, the last thing you want is something complicated and innovative. What you want is a nice, simple process that everyone's familiar with. And you can look up what the rules are and you say this, and this. I mean,
That seems to be a better way to encourage SMEs. Innovative. And in the context of big, complicated projects, it's always been possible to do that under the competitive dialogue or under the competitive negotiated procedure to design appropriate procedures. So, yeah, I mean, I think going back to what the Green Paper said, there was quite a lot of sort of hot air about this scope of innovation.
I mean, the thing is that, and I guess, because we're under UCR, so we've got personal freedom and before innovations are under PCR. A lot of my recommendations to my internal customers are not just about what procurement regs are. And I found actually today really reassuring that things will pretty much stay the same. But I think a lot about how does it look on the front page of the Daily Mail, because I think that's actually the much more dangerous thing, because it's not so much the legal issues around that, it's more the reputation if you are not transparent enough.
Wrap up my little
It does lead on nicely to my evolution, not revolution. This is actually an in-joke between me and Steve, which I'll tell you about. So we did a challenge a few years ago where we were acting for a challenge. It was a 2-horse race, and we were acting for the challenger. And they were presented with this ITT, which was full of innovation, to your point. Full of, we want something new, we want something exciting, we want something different. So they put in this wonderful thing which was new and exciting and different. And then they lost, and they got the feedback on the winning bidder, which said, the winning bidder's bid gives us load of confidence. And we got a copy of the winning bidder's bid, and the first line that says, we propose evolution of evolution. That's the in-joke. So the winning bidder's bid in that case effectively didn't meet the criteria, we said, because it wasn't innovative enough. And I think that's a little bit like an analogy here. The government has said, we're going to do lots of innovation, it's going to allow lots of innovative procurement procedures and so on, but actually it's more of an an evolutionary thing. I've already mentioned this point about interpretation, which we discussed. I mean, I think the impact of the loss of EU case law could be quite significant in some areas. I touched on the public works contract point, which anyone is familiar with. It's not just that. There is a lot of underpinning of the case law which will have to be reinvented, and that will be the test cases that Steve mentioned. And there may be opportunities for suppliers to take chances, perhaps that they wouldn't have otherwise said. But equally, it gives rise to a degree of uncertainty. And we'll have English judges interpreting English law in an English way without the sort of principled overlay of EU law. Could lead to quite authority-friendly decisions if the automatic approach to automatic suspension and injunctions is anything to go by. We've already talked about social environmental criteria. I know that's a great interest in other people. Say more, yes, maybe. We've already got a lot. You touched on that. But the use of the dropping of the most economically advantageous tender from the meat to the mat, I think will create a sort of psychological boost for authorities who are looking to procurement more carefully and environmentally ways. We talked a lot about supplier exclusion. I think that is a really important issue that suppliers to government are going to have to look at quite carefully, also authorities and utilities. Use of frameworks. Frameworks are everywhere. We have lots of frameworks. I think it's only going to expand. Dynamic markets, I think, as I said, will also become important. I think, unlike dynamic purchasing systems, that's going to be much more flexible and useful. For suppliers, it's going to be important beyond dynamic markets and get yourself qualified. I said notices galore, lots of notices, as I mentioned, but actually, will transparency improve? I think that is an open question. And on procurement challenges, as Steve said, I think it's a question of watch this space. Are we going to get lots more challenges? Maybe in the short term, but query in the medium term. And that's it.
Does anyone have any more observations? And thank you, by the way, for your comments throughout.